Thanks a lot for being here today, John. It's good to see you.
Yeah, thanks for having me. Good to see you too, Gene.
So there's a lot that we can talk about, but one of the things I thought maybe we could just start with is, why don't you tell the audience a little bit about your practice, what you do, maybe the type of client, type of work you're doing, just so we kind of get an idea of from where you're coming from.
Yeah, okay, sounds good. Rogitz Associates is a boutique law firm based in San Diego. We do mostly high-tech work. We do a lot of AI right now, but it's mostly computer-based and consumer electronics-based. We do some medical device work. Pretty much anything that's not biotech or pharma is what I tell people. Most of our clients, we get most of our work from the larger institutional type clients, but we help startups and solos too. I like helping them. I think it means something different to them. It means more in a lot of ways to them when they get one patent or even a couple patents than it does to a big company. And so even though it sometimes can take a little more time or something, I really enjoy helping them. And so, that's just what we do, and we crank away mostly in high tech, like I said.
So with respect to high tech, there's a whole lot of stuff that can qualify as high tech. And I know a bit more, because we're friends. I know what you work. But what do you do more often? What are the top 2 or 3 areas within high tech that you focus on?
So, a lot of our clients are implementers, and they're in the computer industry. So we do a lot of, it was rules-based software for a long time. Mm-hmm. Now it's AI. We do computer hardware. I've done autonomous vehicle work, IoT, the list, AR, VR. I mean, they do, they all sort of, it's almost like an arms race in a lot of ways for this stuff. And even if they're not implementing those things per se, they're still getting patents in that stuff for defensive reasons. And so,
Yeah, and all this areas that you just mentioned have in common is they're software related.
Right.
So does that make up what percentage of your work? Because
by
now it's like almost 70% of all applications have software in them or related to in one way or another.
Yeah, I would say probably at least 80 to 85% of our work comfortably. We do have like a medical device aspect to our practice, which is hardware. And then we do a lot of computer hardware as well for our clients when they have hardware to go along with whatever software they're doing. Mm-hmm. But yeah, it's almost all software, I'd say.
Yeah. It's cool. And who's your? Well, I probably shouldn't ask it that way. But have you seen any like inventions that you can talk about, maybe just generally, that you thought, wow, this is really cool. I'm glad I get an opportunity to work on that.
Yeah, there's probably a lot. We work for a really big video game manufacturer of consoles and stuff like that, and so we do a lot of stuff that comes to the actual implementation of video games, like inventory coaches that tell you what types of weapons or assets you should be using in the game, AI that tells you how to beat the game, if that's your thing. I know a lot of gamers don't like that per se, but it's stuff like that where this is useful and it's going into a product and people are actually they're going to use it. It's not you're not just getting patents to get patents. This is stuff that's actually going to be used, and I really love that. Yeah,
in the video game area, it really is a great space, because it's to some extent recession-proof, the same way a lot of the entertainment industry is. And so software interface with the video game marketplace is a really great place, and you see a lot of real cool stuff.
Yeah, 100%. Yeah. We also work for a TV manufacturer. I've done a lot of ATSC 3.0 stuff. Wireless communications and just stuff that goes around implementing that standard. Mm-hmm. And again, the reason I like that is it's the same reason, because this is stuff that's going into products.
Yeah.
We're trying to set standards. This is going to be used by the business.
Yeah. Well, what I'll say is, and maybe this exists. I don't think that this exists, but once upon a time, I used to be a big video game guy, and I haven't played video. I haven't had time. To play video games. Now I want to get back into it, and it's like in order to start with a franchise like that's been around for so long, they assume that you've been playing it since the first version. So if I have a request to your clients, tell them to create some kind of like a tutorial that you like an overlay. Like you could plug, like you used to be able to plug things in together and have them function as modules. Yeah. A module for like somebody like me who hasn't played this but wants to play it. That would be fantastic.
Gene, I can't go into any details, but trust me, stuff like that's already in the works.
Yeah, I feel it has to be, right? Because I want to play these games, and so many, and I get frustrated. I know this probably isn't what we planned on talking about. But it's fun. I find it fun. The tech is fun.
Yeah.
I'm a tech consumer.
Yeah.
I used to be a much better video game
yeah.
gamer than I apparently am now. But it's a complicated world out there, you know, and it seems like the video games today are made for a kid who has all the time in the world and is just going to like go through these universes and learn little bits and pieces along the way.
Yep. Yeah, 100%. But it's so much of the tech that goes into video games is not necessarily, it's not applicable just to video games. I've done a lot of motion capture stuff, which can be used for movies and all kinds of other things. There's a lot of really sophisticated tech that goes into this stuff that can then be applied to other fields too.
And once the computer technologies in memory and bandwidth get to a certain level, you have all these creators almost instantly know how to use it up and do real cool stuff.
Yep. Well, you know, I'm old enough to remember what the world was like before cell phones. The cell phone itself is like what you're talking about. I mean, it's literally the entire wealth of human information at your fingertips. Just stand back and think about that for a moment. It's really incredible compared to where we were with like pagers, right? and the Zach Morris giant cell phone that you used to hold up to your ear. You know, I mean,
it's funny. We were just watching TV last night, and it was one of these shows on Netflix. It's probably 15 years old, and the guy, he had a flip phone. And it's like I can't even hardly remember when we were using them. It's just it is fun, and I'm a geek on all levels, right? So I also like watching Expedition Unknown with Josh Gates.
I've watched that show. I like it.
So he did one recently where he was flying in a World War II era, like one of the last surviving of this kind of plane. And he got up there and they were telling him about all this, all levers and buttons. There's no computer. He said, so answer me this. What is the most sophisticated computer right now on this plane? And he said, the phone in your pocket. Because none of this does that. But nowadays you can't do anything without a computer.
I know. Yeah, it's really incredible. And like have you seen old photos of like mainframes and gigantic like rooms filled with components? And the processing power in my phone is more than that now.
Those times are gone. I mean, this is a computerized world, and this is why it bothers me. Unless maybe we can get back into the IP conversation I think we thought we were probably going to have. But this is why getting software right from a patent law and innovation policy standpoint really matters, because it touches everything. So what do you see at the office? I mean, what is the good? What is the bad? And what maybe would you change? So let's maybe start with the good. What do you see that makes you think that, the system works? It's not all bad, because in the software area, it's easy to say it's all bad. But people your clients get patents. People are getting patents. So what's going on right?
Well, I did want to go with the response that nothing's going on right, but I think.
Well, we can talk about that let's talk about that in a minute. I mean, like, what is going on? Because it's gotten better, hasn't it?
It has. So I just reread the AI guidance again a couple days ago, hunting for something, and there is some helpful language in there. I think when it comes to AI, so like I think it was most or AI is patentable or something like that. I mean, there's helpful statements in there that might not be particularly persuasive on their own, but they can sort of be cited as further evidence for the examiner. I think the 2019 PEG that Iancu did it really did a lot for my practice personally as a prosecutor. The drawback is that it's just sort of kicks the can down the road for litigation, because it has no effect on that. But it did, as far as getting patents, it made it a lot easier. It took out a lot of the 101 rejections we were otherwise seeing. So that helped.
And it kind of, in my mind, that 2019 eligibility guidance really seemed to try and bring us more in line with the European approach. A technical solution to a technical problem. And if you have that, and you actually have the time to be able to write it up and describe the technology, you're probably going to be okay.
I think that's true. Now, I have another problem with the PEG in the abstract, I guess, which is, and it goes to the infirmity of the overall patent system. But it shouldn't be up to federal agencies to distill and interpret case law the way they have, and then layer on another step on top of the existing common law test. And I know why the Patent Office did it. I appreciate that they did it. But I think that that's not the way our system is meant to function. And in the end, it did a lot of good, but it's not the way an American form of government is supposed to conduct themselves.
No,
right?
I hear you. And I think what Andre and his team did was great. I think it was absolutely needed. But I understand what you're saying, and the reason why it was needed was because the courts had gone so off the rails, right?
Yeah.
These judicial exceptions, they're judicial exceptions because they're not in the statute.
Yeah.
Because you can satisfy the statute, and the Supreme Court said, well, that's still not enough.
Yeah. Well, it's worse than that, because, correct me if I'm wrong, but I think the history of eligibility law was that these exceptions predated the 52 Patent Act. Mm-hmm. Then they had the 52 Patent Act, where they enacted our current 101, and they didn't mention the exceptions. And normally a principled judicial approach would instruct that means that they knew, Congress is presumed to have known about the exceptions and not codified them, therefore they no longer exist, right? Mm-hmm. But the Supreme Court just said, no, they still kind of exist. And it's just bad. It's one bad decision after another. And when it comes to the Supreme Court, most of the time these IP decisions are unanimous. They're unanimously wrong, but they're unanimous. Alice and KSR were both unanimous decisions.
Yeah.
I mean. Yeah,
and we've spent some time talking about both of those over the last day because you're in town to join one of my classes tonight, which I appreciate that. I think the students will really like that. Yeah. So we've been talking about obviousness quite a bit. And since you brought it up, one of the things I want to ask you tonight to talk to the students about is when I look at these file histories to try and put things together so that they can learn from, I just don't see people making arguments about KSR. I feel like, and it's not just patent attorneys, I think it's examiners in a lot of respects are kind of just ignoring KSR. And that's one of the frustrating things about patent law, because you have some examiners that are doing it this way, and then they also focus on the technology, and it's hard to compare apples to apples here, right? Because everything's different on some level. Yeah. But you have this pocket over here that does it this way, this pocket over there that does it that way. You know, these examiners handle 101 this way, different examiners handle it different ways, and I almost don't know what to tell people anymore.
There's nothing to tell them. It's a crapshoot. You can't guarantee anything.
That in and of itself is a problem, and that goes back to what we were just talking about, right? The Patent Office had to give examiners guidance on some level that they could follow because the courts were not.
Right. The courts have been completely schizophrenic, especially the Federal Circuit. But as far as, citing KSR, they toss out a motivation because they think if they've made a factual case, the motivation doesn't matter anyway. And so I think for them, it's a very practical reason they don't discuss KSR. It's because they don't have to. Right. For us, obviously, on the other side of the table, we're not going to discuss it. Why would we? Right. I mean, there's so much harmful language. Kennedy just, blathered page after page in that decision with harmful dicta that was completely unnecessary to deciding the case. And he created so many, I don't know, a dozen? I don't know how many bases he created for making an obviousness rejection now. It's crazy.
Well, the one that was really scary was the obvious to try, right? Yeah. Because if it's obvious to try makes it obvious, then everything's obvious, except for the stuff you accidentally invent. Yeah. And Judge Rader in Ray Kubin really put good explanation on obvious to try. It can't be just obvious to try everything. Yeah. And it can't be one of these invitations that, if you tried researching this path, maybe you'd be successful. Yeah. Well, that's not enough. Yeah. But obvious to try is a very scary one. And all of KSR is very scary because if the examiner brings it up and starts using the right language and making the right findings, it can be almost impossible to overcome.
Right. Yeah, the current state of the law. I mean, that KSR controls everything still. Now, the Federal Circuit tried to walk it back a little bit subsequent to that. I've seen multiple presidential decisions that say evidence is still a requirement for motivation to combine. You know, it's a legal determination based on fact, at least. And so you can sort of hold an examiner's feet to the fire on that. But really, if they're savvy examiners, they will find a way to abuse KSR to make their case. And to be honest with you, I don't blame them. They're playing the game the same way we are as lawyers, and we all have to deal with this horrible case.
Right. Yeah. And if people listening haven't looked at a bunch of file histories lately, I would encourage you to just go and look at some file histories, and what you will find is, and particularly if this is not your experience in the space that you work in, pick some other space, go and look at and see. And what you will find is other attorneys are just arguing teaching, suggestion, and motivation.
Yeah.
And are winning on the obviousness fight on just that alone.
Yeah.
And we've been kicking around why that is, and what you want to share with folks what you thought maybe it might be.
Yeah, so I was just getting creative, and I'm sure that there's a counter argument to this, but you know, if evidence is still a requirement for the ultimate legal conclusion, as I just said, then on some level the TSM test is still the controlling test, because throw out teaching, I mean, if you need evidence for a suggestion or motivation, I mean, that's, you know, you need evidence. That's the TSM test still, right? I mean, the problem is that examiners are completely unreceptive to that argument if they don't want to be, right? But I mean, I still think on a certain level, with the Federal Circuit reiterating that evidence is required, in a way they're sort of trying to reinstitute the TSM test just surreptitiously.
I think there's something there, right? Because a lot of the times the examiners will simply, it seems like, conclude with very little more that it would have been obvious for somebody of skill in the art to take this primary reference and then add some component from the secondary reference to achieve the invention. And there's no why. There's no explanation as to why that is.
Yeah.
And if it's because there is an expectation of success, which is really runs through the other 6 of the factors under KSR, they would need to have something to point to and say, because.
Right.
And they often don't. And it's not just that they don't because they don't want to, I think, or because maybe they're being lazy. It's because the examiners are not in the position to do that, right? It's not, examiners don't get discovery. They don't have an independent expert that they can consult. They're doing it all on their own. It almost seems to me, the more I've thinking about this as it's coming out, KSR really is a litigation issue. I mean, it gets applied in pockets in the office very, very strictly. But you almost as an examiner can't have the why developed enough if the rest of the body of law stays the same.
Well, I will say this. So even with the requirement for evidence, the current test is more expansive than TSM, because TSM required the teaching, suggestion, or motivation to be in the reference itself.
Right.
And now they can go out and hunt wherever they want for it. And so it is different in that respect.
Yeah.
You know, if they want to be difficult, they can be difficult.
Yeah. And that is part of I think the problem at the patent office is you have, and I do talk about this a lot, you have some examiners that are philosophically more inclined to allow, and you have some examiners that are philosophically less inclined to allow. And both can be perfectly legitimate views of the universe, right?
Well,
and of the law and of the technology and with it being very hard to compare apples to apples, but somewhere along the line, I do feel like we've created a patent system that is, there's some kind of a break, a disconnect between some art units where it's so easy to get patents and other art units it's so hard to get patents.
Yeah.
And I don't know why that is, and I don't know why it's so difficult, because it's administration after administration that problem persists.
Well, I think, there's going to be variations in opinion. That's human nature. And even the patent system at its best decades ago, there was always a level of subjectivity in the legal tests that were created, right? What's a real suggestion? What's a real motivation? You think it's a motivation? I don't. It's some opaque statement in the reference, right? And so, even when we try to institute these objective tests through the common law, there's always going to be an element of subjectivity to them that we cannot take out of the process. And that's, it's that way in patent practice. I mean, it's a crapshoot. Like we were saying, you never know what's going to happen, and it really is, up to the examiner's own tastes whether they're going to allow the case or not. They can be difficult or not, and you really don't have any recourse. It's too subjective now, but even at its best, it was subjective, and there's just no way to fully take that out of the process. What's obvious? What's a technical effect?
Right.
Yeah,
no, there's a lot of things that are difficult to understand and to explain.
Yeah.
And I don't know what the right answer is. I think the patent office historically has operated under the assumption that they do more harm if they don't give rights that should have been given than if they give rights in the cases here and there where maybe they shouldn't have gotten patents. So you do more harm by withholding patents than you do by allowing them. And then this narrative around patent trolls and bad patents and everything just ran crazy. And now it seems like it's flipped, that by and large, many people, if not most people, see that there's more harm being done by issuing patents than in rejecting patents. And they don't see the underside where, this person's never going to get funding if they can't get this patent. They're going to get run over by the big players who are just going to copy them if they can't get it patented. And I think we need to pick a lane. And I understand there needs to be an error correction system. I think every system needs an error correction system. But I think we do much more harm by not defaulting towards giving a patent.
Yeah.
But
that's a symptom of a larger problem in our society, which is that we just don't respect private property rights the way we used to.
Right.
And there's different kinds of populism that are sort of permeating our society right now. But one form is that private property rights should not take precedent over whatever social cause you think is more deserving. We see it in the pharma industry with the drug pricing debate, right? Like, and they the anti-patent forces sort of try to tie into people's emotions. Like, oh, how can you charge this price for this drug that this person needs just to get through the day or to live till tomorrow or something like that? And it's just they're making fundamentally flawed arguments. With the pharma debate, it's not, well, you can have a higher price or a lower price. It's you can have a price or you can have no drug at all because it wouldn't exist without them being able to recoup their R&D. Right. And it also happens that all of the R&D has to be recouped here in the U.S. This is a point you've made. I'm sure I got it from you originally. Because everywhere else has price controls and they're capitalizing on our system. And I think
I've been trying to beat that drum. For a long time.
Yeah. But we as a patent bar need to speak up more on these issues too. We just sort of let these debates happen in Congress at committee meetings and stuff like that. And we're not speaking to people day to day, writing on IPWatchdog about it, things like that, at least not to the level we should be, to provide the counter argument, to provide the argument for private property rights and free enterprise.
Right. No, I know. I mean, the conversation that needs to be had, like in the life sciences industry, isn't to take patents away in the U.S. or make it more difficult to get patents in the U.S.
Yeah.
What it is it's to get the rest of the world to pay the fair share for the drugs that we create here. And not just American companies. There's a lot of good worldwide pharmaceutical companies, but they all come to America because this is where you can make the money on them.
Right.
And, and until the rest of the world... And I am not trying to you can't squeeze hard enough to make a rock bleed, right? So there's certain countries where you can't expect, they're just impoverished countries, right? But there's a lot of not impoverished countries, a lot of Western countries where people are very wealthy and they don't pay nearly as much for drugs.
Yeah, but
that's not fair for Americans either. I mean, it's not good for anybody.
Yeah. But those countries are too far gone. If we can't convince our own population here in America, we're not going to convince them.
Right.
They're
then
even
what
farther
winds up
down
happening is then you get the politicians saying, we're gonna clamp down in the U.S. You can't have patents on this. We're gonna take your patents away. Yeah. We're gonna et cetera, and if that happens, then a lot of these companies will just go away. And
right.
You can force somebody one time to take their blockbuster drug away from them, and there won't be a second time because there won't be another blockbuster.
Right. Right. But people, I don't think they understand the history of innovation. I don't think they understand on a fundamental level how economics work. Mm-hmm. Motivation for making a profit isn't a bad thing. It's made out now to be as if you're just being greedy or something like that. But I think part of the brilliance of the founders in the first place was that they found a way to harness that for the public good. Right? To harness that sentiment, to give people a financial incentive to better humanity. That's the whole reason for Section 8, Clause 8.
Yeah. And not only that, but they knew they were setting up a system where people were going to license rights.
Yeah.
Because in the early part of the country, over 80% of inventors did not even have a high school education.
Yeah.
These were not people that had any access to the stream of commerce. They were never going to be able to manufacture it. They didn't control any channels of distribution.
Right.
They were going to create something, and if it was valuable enough, then they were going to be able to license it to somebody who controlled manufacturing facilities or who had the channels of distribution. Why is licensing a bad thing?
Yeah, it isn't.
It's not. I mean, I think we've got to get away from any particular act being bad or making you bad, and realize that people on both sides of the V can engage and do engage in activity that is bad. I mean, I think the way you define a patent troll is by the activity, not by what they have chosen to do in terms of the business model.
Right. I agree with you. I've made this point. It's not a cut and dry area. There's a lot of gray in there, right? Like I was saying earlier on this podcast, I work for implementers who are filing in areas they're probably never going to implement in. So if they try to sue someone in that area, are they all of a sudden a patent troll, even though they're some of the biggest implementers in the nation? Yeah. I mean, it's an oversimplification of a bigger problem. And to be honest with you, I'm not even sure it is a problem, at least not to the great extent people make it out. I think you believe in the patent system or you don't. Why is it that if you're a solo or you're a startup and you have a great idea but not the means to actually bring it to market, that you can't still monetize it and further the goal of Clause 8?
Right. There's all kinds of companies. The whole product is the research.
Yeah.
It is the development.
Right.
And those companies have really suffered over the last 15 plus years.
Yeah.
It's almost 20 years since eBay. It's 18 years since eBay.
Yeah.
And that was one of those moments in time that just changed. You had, and I don't understand why more people don't get it, but you had it, and you still do have a situation where you have an exclusive right up until you're victorious in litigation. I proved, John, that you stole this, you infringed, none of your defenses worked, and my patent is still valid.
Yeah.
And all of a sudden, I no longer have a right to exclude.
Yeah.
And it's like that just doesn't make any sense to me whatsoever.
It doesn't to me either. It's still a property right. What if I told you someone's trespassing on your property, but you only have a right to monetary damages? The police can't come and you can't get a restraining order to keep them off your property. And that's so counterintuitive.
It is. And like so many things in life, like we were just talking, like the real problem with drug pricing is not patents.
Yeah.
Patents are rounding error. I mean, the R&D cost, the regulatory costs, just the scientific the hurdles to just make it happen. Those are the costs, right? Patents are a rounding error in all of that. But that's not the narrative that's out there. So, but rather than having the difficult conversation about who in the world is actually paying for these drugs and the reasonable rate of return that the investors demand for the money that they're investing, rather than having that conversation, which is a difficult conversation, we have the patent conversation.
Yeah.
And the same thing happens with respect to injunctions, for example, or who is a patent troll. For a while, patent troll just meant the patent owner who's suing me. You know, everybody except for me is a patent troll. And that can't be right. And then I understand and I'm sympathetic to the fact that the high-tech industry, like the folks that you do work for, they have so many things that go into these products and services, thousands of patents maybe. Well, that's a different level of problem and concern than like a pharmaceutical, for example, which is all the way on the other end where you really only need one patent, and it has to cover whatever the FDA approved. And if you have that, then you're good. So somewhere in between, we have this one-size-fits-all patent system, and rather than have the difficult conversation about, well, okay, maybe if you just bought the rights, you bought the rights in bankruptcy, well, maybe you shouldn't get an injunction. I don't know. I don't know that that's the answer. But rather than have those kinds of difficult conversations, we get treated like, and I say it all the time, like we're in third grade. One person talked out of turn, so the whole class loses recess. And I would like to really identify where the problems are and say, okay, let's fix that. Rather than in the engineer in me, why throw away the whole system? Fix the problems. Because you throw away the whole system and you start fresh, all kinds of new problems that you could never have anticipated are going to happen.
Well, I think a lot of it is just the nature of government. They're just not very effective at fixing problems in the first place, right? That's why we have the private sector. That's why our framers were so brilliant in instituting the IP system in the first place, because they knew that real progress in humanity was going to come from the private sector, from monetizing these sorts of ideas. And I think it's the nature of government to be lazy and to go for the lowest hanging fruit, or like the easiest argument, even if it's not a really valuable argument. It's just what they do. And, you see this going on in the halls of Congress right now. And I hate it is both parties, right? I mean, Darrell Issa, who has patents to his own name, sometimes comes out with positions that I think are sort of anti-patent.
And he made a lot of money, as I understand, with his patents. It's unfortunate. And it does feel like we have a situation where people who have made it are pulling up the ladder. And I don't know that that's a fair criticism of Issa. I know people who feel that way. But it certainly is what happened with much of Silicon Valley, right? Most of those companies they all started small. I don't know any of them that started big. Some of them started with two people literally in a dorm room with a folding table, right? And then they made theirs, and they're pulling up the ladder behind them. And I don't, on some level, I can't get too upset because I get it. I mean, you're not going to advocate for policies that are in somebody else's best interest. I just wish we had the judges and politicians being a little bit more discerning to know when somebody who's making an argument, the Silicon Valley company, that benefits them, that you could cut through that and say, that might not be the best policy for the country or for the industry, and it certainly hurts smaller innovators, and that's where you get the real cool innovation often. The risk taking is when you're small, not when you're big.
OpenAI. I mean, they're big now, but they weren't. I mean, that LLMs, that whole thing came from them basically, and they were a startup. A virtuous one, I guess, if you believe Elon, and I tend to. I think at their inception, that's what they were, just trying to do really cool things as a startup to better humanity.
Just shifting gears just a little bit. I know you've taken a look at a lot of the AI solutions for lawyers, tools that are available, and that sort of thing. Just general question, what do you think about the state of tools?
Well, I think they're all pretty poor right now, and I don't blame them for that. Again, this whole LLM thing, it's still relatively new, and they're figuring out as they go. And I see improvements in the products. Month after month, I see things getting better, but it's just not anywhere close to the point where it's useful. And even to the extent that it spits out something useful, I can't trust it because of the hallucination problem. And then I have to go and validate it. And then I'm like, why did I just do this intervening step? I might as well have just sought out the information myself and written it, right?
So before we go any further, it sounds like you're talking about the generative AI.
I am. Yeah, I am. I'm talking about preparation. Even when it comes to prosecution, they're not that good. And I think, I'm not sure they'll ever be that good there. I think that probably writing patent applications comes first with those tools, and that they'll be more effective for that. I'm not sure they'll ever be effective for prosecution. I mean, maybe they can assimilate vast amounts of information, but are they going to really be able to understand Federal Circuit case law the way we do, and claim terms the way we do? And the fact, I mean, generative AI by its very nature is generative. It's giving you content, and part of prosecution is less is more. Right. And when are they going to realize when to shut up as an AI tool?
Well, just even with the stuff that we're talking about with obviousness, I mean, there's a lot of ways that the examiner can phrase the rejection that clearly don't require you to say anything about KSR. And I say that because I see it. You know, I see people just arguing TSM and winning.
Yeah.
But then there's times when the examiner is going to say something in a certain way, where use a certain word where you know that, okay, well, I have to go into my KSR toolbox because TSM is not going to cut it. And I don't know how you could train AI to really know that. The other thing I always, another friend of mine, I won't name him, you know him, but friend of ours, he's told me, we've talked about means plus function claiming. It's like, you can't know whether it's going to be means plus function unless the Federal Circuit's ruled on it.
Yeah.
You know, because some of these cases is just like what is and what is not means plus function. It defies logic to me.
Yeah.
You know, and so if you can't get at least 9 out of 10 patent professionals to agree to something, how are you ever going to get AI to learn it well enough so that AI can do it? I mean, because right now a lot of the patent issues, half of the bar would say one thing and the other half would say the other, and I've got cases to back me up and you got cases to back you up.
Yeah.
That's not a universe for AI to grow up in.
No, it's not. And so I have my doubts that it'll ever be effective for prosecution for that reason. And maybe I'm biased because I don't want my job to be obsolete one day, but I think that there's always going to be an element of human involvement in these sorts of things. There just has to be, right? Especially if you're using the tool and you're signing your name out. You'd better be darn sure that it's what you're doing is accurate. It's not a hallucination.
Right.
It's legally sound. It conforms to the case law. You know, it doesn't use patent profanity. That's the other thing. You know, these AI systems, they're trained on vast amounts. Even if it's just if they're specific to patents, there's a lot of really bad patents out there. They were poorly written, and I'm not even talking about just because they were written under old case law. Using words like the invention. I mean, there's just a lot of poor draftsmanship out there. And if it's training on that, it's garbage in, garbage out. Right?
AI can mean a lot of things. I think generative AI right now is not probably where we need it to be using this as a solution or even to save time because of all the reasons you were just talking about.
Yeah.
Where I've seen in our space that some of the tools do really, I think, really cool stuff.
Yeah.
Is interfacing with the inventor and almost working as, you know, like helping brainstorm.
Yeah.
You know, the inventor can type something in and then it comes back and it asks you questions. Did you mean this or did you mean that? Or did you know about this? Or then you answer questions, then it gives you more. And it kind of is like leading you down the path.
Yep.
But it's you. But it can pull stuff out of you.
Yeah.
And I've seen some stuff, and then it also is pretty good at at least first cut of searching to find stuff that you maybe didn't know about. And then when you see that in front of you, it's like, well, how does what you said differ from this?
Right.
Well, now faced with that, well, I can articulate how it's different because I know it's different.
Yeah.
And so I think a lot of these AI tools at the front end, at the innovation harvesting level, are really pretty interesting.
I think you're exactly right. I won't name the company, but I've got a buddy who helped start a company that was like that. And it wasn't just asking questions the way you're talking about. The tool can actually monitor the channels of communication in the company. You know about this, right? And it can It can identify potential inventions and filter it to in-house counsel for follow-up, which is incredibly useful because these in-house guys, they have limited resources, and it's just such an effective way of really sort of drawing the most out of your employees and not having it just be the same people who know about the invention disclosure process. They know about the incentive process if the company has one or something like that. And you can really harness the full scale of the company to innovate and to provide value to the company.
A lot of times you don't know that Jack in California is working on the same thing that Jill in North Carolina is working on.
Yeah, exactly.
And nobody would know. And then it runs across the IP Council inside IP Council screen, and now he or she knows that, well, I need to get Jack and Jill talking together because that's something the company's interested in.
Exactly.
And they're both working on
it. Yeah, it's a really useful tool. I can see how that's valuable. When it comes to searching, another thing that you sort of alluded to, but I think it's worth discussing a little further, is that I've seen tools that not just find really good prior art, but they'll give you a generative output now that explicitly compares the invention you gave it to the prior art for every single piece of prior art. They'll say, this is what it is, this is what yours does, here's the differences. Boom, boom, boom. And it does that for every hit. Right. And it's useful.
Can
really
you do
useful.
that? So I could see that would be really very useful for during prosecution, and not maybe relying on the machine to give you that, but like, okay, the examiner's using these 3 or 4 references. Mm-hmm. Let me run those references through this tool to see how it really is different from the disclosure I filed. That would be fantastically interesting.
Yeah, it just gives you a point to go off and do further investigation.
Right, and then you as the professional get to understand, okay, well, that's really different because of this, and if I claim that, and it's exciting times. I think just my 2 cents, and you can agree or disagree. I think AI does some things very well, and I think when you're asking it to do discrete tasks, finding, searching, comparing, does very well. Yeah. When the generative AI, that's where you get all kinds of problems and hallucinations. Now, it's getting better, as you say, every almost weekly, it seems. But there's a long way to go.
I think there is. I think my expectations were maybe unreasonably high at first when I started using testing these patent drafting tools, and I expected to give it a paragraph the same way I get a paragraph sometimes, or a couple sentences, and to spit out a complete patent application. And what I've found in using these tools is that if you are more targeted, if you give it specific, give me, for enablement, how does Wi-Fi work? What standards does it use, or something like that? And you're not just like, give me the entire patent application, but you still sort of manually build it out with cut and pasting, right? And you give it very targeted things to answer. It can be effective doing that, but it's just not and again, it was probably my expectations to think it was just going to give me a complete patent application.
Well, but no, I mean, okay, there's 2 reasons why you might think that, right? It's because what passes for an invention disclosure, and the invention disclosure, I joke around by, it's like, hey, this class I'm teaching this summer, they say, well, when is the patent practitioner a co-inventor? And I'm like, well, probably 100% of the time, because you get like a paragraph or 2, usually.
You said the quiet part out loud.
Yeah. And so there's that, and we do that, right? And we know how to do that as a human actor. And then there's also with the AI, the way that it was sold. I mean, and I'm not talking about, like the real reputable company. And, insert reputable, there's all kinds. There's PatSnap, IP.com, LexisNexis. There's, any number of entities in Aqua that have been in the industry, that work with professionals. They know what we do. They know what we need.
Yep.
That's not who I'm talking about.
Yeah.
But you get all these inquiries by Joe Smith, who last semester was was in college, and this semester he's got an AI company.
Yeah.
It's like, okay, well, and then they would send these emails around. I mean, I'm sure you saw these. We were laughing about them at some of our programs, right? It's like, well, it takes you right now 2 hours to draft an application. With our tool, you'll be able to do it in 15 minutes.
Yeah.
It takes you right now 45 minutes to respond to an office action. You'll be able to do it in 5 minutes.
Yeah.
It's like, okay, well, if it took you 2 hours to draft the application and only 45 minutes to respond to an office action, nobody would need your tool.
Yep.
They need your tool or are interested in your tool because it's an order of magnitude more work than what you're saying.
Yeah.
So then your estimates on what you're going to time to say me, I just can't believe you. And it's clear when it's somebody like that doesn't get it.
Yeah.
But you just have to be very and the other thing about this too is with the companies I mentioned before that work with us.
Yeah.
They are long-term partners of professionals in the industry. Mm-hmm. They understand how important confidentiality is.
Right. Yeah.
Because that's the huge unspoken issue. Maybe not unspoken. People talk about it.
Yeah.
But a lot of times I don't think they do enough investigation. Is this really going to stay confidential?
Yeah. And even if you do your due diligence, you can never be fully certain. And I don't want to cast aspersions on a lot of the reputable companies that are out there. But, with big tech companies, we've heard time and time again, we're not doing this, we're not doing that. And then a whistleblower comes out or some documents get released and it turns out they're doing it. Right. Whatever they said they're not doing. And these are companies that I would also consider to be reputable, or at least big enough that they should be reputable if you're not skeptical about them. And they're doing this sort of stuff. And you can't fully trust anyone. And there's probably never going to be a solution to that concern. At some point, you're just going to have to take the leap, right? I mean, if you're using OneDrive, you went with Microsoft, they're probably it's as legit as it's going to be, right? And at some point, you need to take the jump,
right?
It's like that with anything, It's there have been other tools, web-based email hosting, right? I mean, you could say that with a lot of things, and it just got to a point where people became so comfortable that it became accepted,
Yeah, and I think that's where we're going to get to. Right now, you just got to be careful. And there's other companies. Another company came to my IP Copilot, and the person who's behind that has 500 patents on his own. Having before he started his own business. Right. I just think you need to work with somebody who knows the industry, who knows what we're doing, knows what patents are, and because that will take a lot of the question out of it, right? Because you know that there's a name behind it. Yeah,
100%. And not all companies are like that. I mean, I really went on a binge of testing these AI tools for a while, and I had to stop. It was taking too much time, but I thought I really want to get into this. And there were companies, I was taking calls from companies I'd never heard of. I'd see them at a conference, and just like they're pop-up companies.
Well, you see them once, and then you don't see them again.
Right, exactly.
And that's the real problem. That's why you got to, I think, really carefully select, one of the companies that's been around that and if they're not around tomorrow, it's going to be because one of the other companies has acquired that company, right?
Yeah.
And it's not that they're going to go away.
Yeah.
They're around for the long haul.
Yep.
And then there are some new startup companies in this space, but people who have personally long track records of developing very useful things, or are like Austin at IP Copilot. I mean, he's got literally 500 patents himself. I mean, this is not somebody for which, I'm going to get into patents. It's really cool. See what I can do.
Yeah.
No, this person knows the industry.
Right, exactly. Or they're AI companies who do AI in other contexts, and they recognize this need too, even if they don't have that specific experience. And you go, well, at least they know what they're doing on a technical level, right?
Right.
And they're not just taking the ChatGPT API and wrapping it up and repackaging it and selling it.
Right, and particularly if they're familiar with, like doing SEC stuff or M&A stuff, because they will get the confidentiality stuff.
Right.
And how important that is.
Yeah, but there are certain companies, and I do tend to trust them the most, that were founded by patent attorneys, or they have patent attorney involvement. A lot of IPWatchdog sponsors I know are like that, and I love that.
Yeah, there's a number of companies that we've worked with over the years where a patent attorney saw, I need X.
Right.
It doesn't exist, so I'm going to create it.
Yeah.
And they do. And that's another, but that's the backstory, right? You need to know what is the backstory of the company.
Yeah.
So this isn't just John Smith, who last week was a senior and walked in graduation over the weekend and opened his or her AI company on Monday morning.
Yeah. And you really need to be that cautious with your company's secrets, right? You really do. You can't just be, throwing that stuff out there to anybody, and I think generally most companies are. They have to be cautious by their very nature, especially the larger they get, the more cautious they seem to be, right? And you need to be in this area. You should be in all areas, but especially something like this, that it's in its infancy right now,
Yeah, and I do tell people that if you're not checking this stuff out and you're not using like some of the stuff that we talked about that works pretty well right now, by the time the rest of it starts becoming usable, you're going to be so far behind the 8 ball.
Yeah.
And I do think you can't be afraid. You just need to be responsible.
Yep.
And there are things it can do right now that will be very helpful. It's not going to replace you anytime soon.
Yeah.
If at all ever.
Right.
We're going to need a lot more certainty from the Federal Circuit before it has any risk of replacing us.
Yeah.
I think the attorneys that have the most at risk from AI are the ones that do clearly what I will refer to, and people probably get upset, but off-the-shelf transactional stuff.
Yeah.
Like for most people, you don't need a $5,000 or $10,000 will.
Yeah.
Like a will for $99 or $149 you get offline is not going to solve all your issues, but it's going to solve most of them, right?
Yep.
So the attorneys that cater to that kind of business, I think are going to be in trouble, because I think the AI, it will eventually, if it doesn't do it well right now, I think it will. That's the exact type of. That's a matching game, right?
Yeah, right. And I honestly don't have a lot of sympathy for people like that, because they're just not doing a very professional job in the first place, and that's what we are. We're professionals.
Right.
You should be trying to do the best job you can.
Well, no, you should, and I think on some level, what we're working on has to be unique.
Yeah.
And right now, the AI is learning based on a corpus of data that's backward looking. And it has not yet shown the ability, and if it does, this will shock everybody, right? The ability to forward think.
Yeah.
And so until it can do that forward thinking and put things together and really, be having like the neurons rub together.
Yeah.
It's going to be hard for it to do the innovation stuff that we do, because something's got to be unique. Somewhere has to be one-off, never done before.
Yeah. And I'm a big believer in humanity in general. And on a theoretical level, I'm not sure computers will ever get there. Mm-hmm. They're just not human. We can talk about how, they're going to be sentient and stuff like that. But are they really? It's still just zeros and ones, right? Mm-hmm. On a fundamental level, I just don't. I don't see it. Human creativity is always going to be human creativity. You just can't reproduce it.
Yeah.
Right?
Well, and the great way to think about that, too, is, you could hear somebody when you're listening to music, play music.
Yeah.
And then you can hear somebody who's really a performer.
Yeah.
And the performance of music is very different than just playing the notes.
Yep.
And I, at an earlier part of my career, I was a co-owner of an independent record label. And we learned that, there was, you have bands and you have auditions and you have acts, and people they can play and they're perfectly fine.
Yeah.
And then you have the drummer that comes in and it's like literally Animal from the Muppets, It's like, okay, that's the guy that I want being the drummer for our best act, because he feels the music.
Yes. Yeah.
And that's what, and probably not during our practice lifetime, probably AI won't get there, but maybe it will. Who knows?
I don't know. I hope for our sake, for humanity's sake, it doesn't. Because otherwise it's reducing us. It's in a way dehumanizing us, right? We're no longer unique and special in a way that we are over the rest of the animal kingdom.
Yeah. Well, the one thing I will say is, if it ever does get to that level, I hope that it has thoroughly been programmed to have Isaac Asimov's 3 rules of robots. which,
okay.
you know, the one that's probably the most important, I will not do harm to humans.
Yeah.
You know, because that's where people start to get, and it's almost fanciful right now. You know, we talk about that, and we do the AI program once a year, and we talk about eventually AI is going to rule the world or potentially destroy the world. And then you see the examples, like just a few months ago, it couldn't even return a picture of George Washington. You know, it returned somebody, an African American gentleman wearing a Revolutionary War costume for Halloween. That was what it returned. This is comical. It's comical. It doesn't know whether Elon Musk's tweets are more harmful to humanity than Adolf Hitler actually was.
Yeah.
You know, and it's like, these are layups. You know, and so until it can get the layups right, I think we're safe.
Yeah, I think you're right. But I also think, so I read a book recently called The Heart and the Chip. It was about robotics and AI being fused together and stuff like that. It's an interesting book for a patent attorney to read. If you like, you know, implementing and daydreaming about these sorts of things. But at the end of the book, that was one of the points the author made, was that we need to come to some sort of agreement that we're only going to use this for good. And I just think that's an incredibly naive take on human nature, and it's never going to be achievable. Even if it was achievable, say here in the U.S., what are the odds that Iran and China and Russia are going to agree to those terms, right? There was a point not too long ago when China was doing cloning that the rest of the medical community said was just outside the bounds of acceptable procedure. And they did it anyway. Right. And that's recent memory. And why wouldn't they do it again?
Well, that's the scary thing, right? That's the problem and even if they did all agree to that, what in different cultures would be considered acceptable is just very different.
Yeah.
You know, it's these are difficult questions.
Yeah.
And it's an interesting time to be alive.
Yeah, it is. 100%.
Right up until AI kills us all.
I thought that I read that New York Times article from like February of 2023 when the guy was talking about that he gave it a prompt and it spit out something that I wish I wasn't constrained by the bounds that my programmers have given me. And I read that and I had a hair on fire moment, like a lot of people did, where I was like, oh my God, Skynet's almost live. You know,
Skynet has gone live.
Right, but then I've talked to AI technologists since then who are just like, slow down.
Yeah, I have to. And I think some of that is a language issue. Yeah. You know, it may have been just trying to say is, I haven't been programmed to answer that question. Right. You know, and it just said it in a way that like sounded like the Terminator. Yeah. Well, this is a great conversation. Thanks for being here, John. I really appreciate it. Thanks. Yeah. Good to see you.
Yeah, you too. Thanks for having me, Gene.